So what is the fee of the I-140 filing, and what is the process to file? What all documents should be included apart from, you said to show the ability to pay? What are the supporting documents apart from the experience letters, and what all should be kept in mind to make sure there is no RFE, and it's more chances of getting an approval?
Well, I think with reference to documents, we have already discussed thoroughly what documents are required to submit an I-140. But to avoid RFEs, again, I think we discussed, because you have to show that the person meets the requirements in the perm. So whatever the requirements were in the perm, you have to submit supporting documents with reference to education, experience requirements as per the perm, skill sets as per the perm, and also the ability to pay documents. Also with reference to, Ranjit, maybe we can talk about
one question I had in mind was, these, you said the ability to pay and all the documents for the employee who is working with the company. You can also, companies also sponsor when the employees are not even working with them. So how does that work, and what things do they have to keep in mind when they are sponsoring an employee that's not even working, or it's a future employee who is about to work?
Right. So then in that case, the ability to pay becomes even more difficult to show, unless the company is a huge company making, a lot of profit. So then they have to show the entire prevailing wage. They'll have to show ability to pay for the entire prevailing wage, because there's no W2 at all. So if the prevailing wage is 125,000, then in that example that we gave, they'll have to show profits of 125,000, taxable income of 125,000, or they'll have to show net current assets of 125,000 to be able to file these petitions. So for a smaller company to file future job employment petitions is very difficult. It's easier if you're a multinational, or if you have, lots of profits, or maybe you are filing on accrual basis your tax return, so you have large current, net current assets in your taxes always. Then it's possible. In most instances, it's difficult, especially for small companies.
Sounds good. How about, a lot of companies acquire the merge. What happens, when they are in the process of filing an I-140, or let's say after an I-140 is approved, and employees, what's the situation of the employees when the acquisition or merger or anything of such sort happens?
Right. So a lot of things can happen right after the labor cert is filed, and the I-140 has not been filed yet. So one of the things that could happen is that the company is bought over by another company. In that instance, as long as there's a successor in interest situation, which means that the new employer has taken over all the assets as well as the liabilities of the company, as long as that situation is there, and even if that company is in some other state, for example, the perm was filed and the advertisements were done in New Jersey, but the new company is now in California. Even if that is the case, an I-140 could still get approved if we are able to show through the agreement, the sale agreement, that the assets as well as the liabilities of that particular person were taken over. So there could be many instances, many ways that one company purchases another, right? So it could either be that the entire company is purchased. It could be that only some employees of that company were purchased in the consulting company scenario. So if you're showing that only some employees were purchased, obviously this person who you're filing the I-140 for has to be one of those persons. And you also have to show that all the liabilities as well as the assets of all those employees who were purchased is taken over by the new establishment. Same way, if the entire company is purchased, then it cannot be just a asset purchase. It has to be the liabilities as well as assets. So as long as it meets those requirements, and that is shown basically by submitting a copy of their M&A agreement, you can then go ahead and show successor in interest. Another thing, sometimes what happens is the ownership of the company is changed. So the company remains the same, XYZ Corp, but the owners, new owners buy the company. Even in that situation, really nothing has changed in that situation because it still has the same federal ID number. Maybe the company's name has changed, but and location has changed, but nothing else has changed. So in that situation also, it's a successor in interest, and it's possible to file an I-140 now. Even though maybe it's at a different location. Third instance, in which some change has occurred. So the company was not bought over by another company, but the company changed its location. So they were in New Jersey earlier, and then they moved to, say, California. In such a situation, unfortunately, the labor cert has to be refiled. You cannot file an I-140 because the market was not tested. Unlike a successor in interest situation where they allow you to file, even though the location has changed, if it's just purely change in location and no M&A has taken place, since the market was not tested, and since it was done specifically for the New Jersey market to see whether there are any available applicants, and California market was never tested, you'll have to again refile the labor, and then only you can file the I-140. Now, there's an exception for this if the location has changed, but the change is within commuting distance. It doesn't have to be within the same metropolitan statistical area or MSA that is prevalent for H1s, but it has to be within commuting distance, which is a little bit more lenient than being in the same MSA. As to what is commuting distance is, of course, something that can be argued. Within a day, you should be able to commute back and forth to work. So that is, within commuting distance. So you can argue that it is within commuting distance, I guess, if it's neighboring states, like New York, New Jersey, Pennsylvania, Connecticut, etc. So that's something within about a 50-mile radius, maybe. So that's something that has to be kept in mind. That's the second change that has to be kept in mind with reference to filing an I-140 after the labor cert was approved.
Okay. Can you explain the timeline of the I-140, a rough timeline? I know it's always changing, and if there is any premium, so what is the fee and all? Could you please explain?
Well, yeah, I-140 processing time keeps changing. You have to go to the USCIS website every time to see what is the processing time. It's usually 4 to 6 months. With COVID, everything has changed. If you want to file premium processing, you have to file the 907 form. You can either file that along with the I-140 application, or you can file that after the fact. Once you've received the receipt, you can file it, convert it to premium processing. They've recently changed the fees for premium processing. It is now $2,500. So they've increased it, and also what they've done is increased the time within which they need to respond for premium processing. It used to be 15 days before. Now it's 30 days. So that's another change that has occurred recently with reference to premium processing. Yeah, but if you don't file premium, maybe 4 to 6 months is the expected turnaround time.
Who can pay for I-140? There are a lot of confusion. Few say employee can, and few say employer can, and only employer can do that, not employee. So can you throw some light on who can pay the fees for the I-140 filing?
So for the I-140 filing, the employer is supposed to pay the fees, not the employee. But it is not statutorily by regulation that the employer has to pay, in the sense that they will not accept a check from the employee, that's for sure. If you send a check from the employee for the fee, the case will be returned because it's an employment-based petition, just like a H1. But the question here is, can the employer ask for a reimbursement of that fee from the employee? And that is a gray area. And usually we discourage employees from doing this because, there have been many scandals with reference to green cards where employers have sold green cards to employees. And, it's taken 10,000, 20,000 for, to file a green card. And they have, then been audited, and there's been criminal investigation against many employers for doing this. So it could present a situation of fraud. It could look like fraud, and you don't want to do anything that looks like fraud. So we always ask that the employer pay for the entire green card processing. But unlike the PERM, where by regulation itself, they have amended the regulation and said that the employee cannot pay by law. They have not said that for an I-140, but it looks bad. So when the employer pays or asks for a reimbursement. So I would suggest that the employer pay and not